My name is Pam Metzger. I'm the director of the Deason Criminal Justice Reform Center at the SMU Dedman School of Law. And it's my great pleasure to welcome you all to the fifth and final Criminal Justice Reform conversation that's part of the SMU Law Review's 2021 Symposium. This very special symposium volume pairs practitioners and professors in conversation about 5 critical criminal legal system conversations about reform. Today's conversation is one about the delivery of indigent defense services, a topic that for us at the Deason Center is near and dear to our hearts, as most of us come from a public defense or indigent defense background. It's also a special one for me because I know both of our guests personally. Our panelists today are Professor Irene Joe, who teaches criminal law and procedure at UC Davis. She thinks and writes about defenders, about caseloads, about ethics, and about, as you'll hear today, blind spots in the delivery of the right to counsel. Before she went to UC Davis, Professor Joe was an EJI fellow in Alabama, but for my purposes of most relevance, she was a practitioner in Orleans Parish at the public defender's office there. Our other guest is Chief Justice Bridget McCormack, who joined the Michigan Supreme Court in 2013 and has been Chief Justice since 2019. For those folks who've been following the conversations about the federal judiciary and efforts to diversify it and put more defenders on it, Justice McCormack is a great example. Justice McCormack began her career as a public defender at the Legal Aid Society of New York. I had the pleasure of knowing her all the way back in law school when we were mere babes, just 10 or 12 years ago. And she went on to become a professor at Michigan Law School, where she co-founded the Michigan Innocence Clinic, which since has exonerated more than a dozen people. She's got a list of awards a mile long, and I'm so thrilled to be able to have her join us, coming from a perspective that is now both professor, practitioner, and judge. So with that, I want to get started, and I want to begin by focusing on the essays that the two of you wrote for this symposium volume. And I'd like to start by asking Irene, can you talk about the topic that you've addressed, which is blind spots in indigent defense delivery?
Yes, thank you so much. I'll start by just letting you all know that it's really a privilege and an honor to be part of this symposium and to be part of this discussion that we're having here today. So my essay, my contribution to the symposium really flows from these conversations that I've been having with two of my students who are also, coincidentally both co-authors on this essay over the last year and a half, Shelley Richter and Deja Tillman. The conversations we've been having over the last year and a half really we're a bit hopeful about some of the reforms that we've been seeing in the criminal justice arena. We mentioned that there was a lot of attention, not nearly as much as, we might hope in some situations, but there was a lot of attention on legislative reform, especially in California when it came to the different propositions that were being passed with realignment and reconsideration of different sentences, lowering sentences, redefining recidivism, and the punishments associated with that. But despite that attention and the celebrations that many criminal justice reform-minded advocates had, we felt that there had been little, if any, attention paid to whether or not those who are meant to meaningfully access those reforms to the criminal process could actually do so without legal representation. By our mind, this was a blind spot in the criminal justice reform conversation, that there was a lot of attention on these legislative pushes, different policy proposals, but not nearly as much attention as to how people were actually going to avail themselves of these new improvements. It's not a surprise that in my conversations with these students, we focused a bit on how we didn't think it made sense to push the responsibility on trial defenders. A lot of my research is about public defenders and their caseload crisis. And we thought instead, maybe this moment in time calls for a reconsideration or new attention to the right to counsel on appeal or post-conviction. So that's what our essay really explores, how paying attention to the provision of counsel for some of these reform efforts would actually give us greater purchase and something stronger to hold on to in the changes that we're trying to see move forward to the benefit of society.
Well, thank you for that summary. So one of the things I love about this pair of essays is that you two are actually speaking directly to each other. And so, Bridget, can you kind of give the audience just an overview of your response, which I know was really enthusiastic, but very creative?
Well, first of all, let me echo Professor Joe's gratitude for being included in this conversation. Thanks to the SMU Law Review. It has been really a pleasure to get to know Professor Joe and her incredible work. Congratulations on your tenure, and to get to see my old law school buddy from 10 years ago in law school, Professor Metzger. So this has really been fun for me, and I'm grateful to be included in one of what's been a really exciting series of conversations, and this has been especially a fun one for me to contribute to. Michigan, like California, has seen a lot of criminal justice reform over the last few years. It's been bipartisan. It's been pretty ground up. There's public support for a lot of the reforms. And I guess the first point in my responsive essay is yes, absolutely. I agree with Professor Joe that there has not been a lot of focus on how to make sure people can access reform, especially when it comes in the form of post-conviction relief, which is what a lot of reform has to look like, right? If we're going to significantly change the number of people who are serving long sentences, we're going to have to have reforms that focus on sentencing and other post-conviction relief. And we know really well from lots of empirical studies that it's hard for most people to manage accessing justice in those kinds of systems, and lots of other ones, by the way, without lawyers. You know, we know from the front end of the criminal justice system the difference lawyers make at first appearance, right? There's tons of studies about that. We know even in the civil justice context, there's great data on evictions, for example, and how people fare when they're represented by counsel versus not, right? So of course, it has to also be the case that people are going to do a lot better if they have counsel. If California is like Michigan, I also have to agree with Professor Joe that the trial level public defenders are already in over their heads. And I think it's been a long time since we have had a significant conversation about reimagining what appellate defenders do. So my first response is amen. I agree with Professor Joe. And I hope we see lots of lawyers, bringing these questions to courts. Judges get to answer questions when you ask them of us, so bring them to us. But my second response was yes, and. Because I think it's time for public defenders in particular to be part of upstream policy conversations. And I use in my essay one particular reform that Michigan in particular, but many states have expanded in recent years, which is expungement, also a post-conviction reform, an important one. We have great data from from two scholars at U of M, JJ Prescott and Sonia Starr, about the benefits of expunging criminal convictions, not just in predictable ways, but others that are a little bit less predictable. And it's hard to argue with their data. And yet, it is extremely difficult for people to manage the expungement process, which is one that there is no right to counsel for. And so folks that have the resources to be able to get a lawyer to help them with that expungement process are far more likely to be successful, which kind of undermines the point, right? So I spent a lot of time in my essay talking about moving solutions upstream and how I think the indigent defense bar should have a particularly important voice at the policy table, which when Professor Metzger and I were talking, and Professor Joe and Professor Metzger and I were talking about this yesterday, I don't think when we were in law school, and she and I were both sure we were going to be public defenders when we graduated from law school, this was not something we were taught to thought about at all. We wanted to be really good lawyers for our clients. but we weren't thinking about the ways the system could better serve our clients. So using expungement as one example, and I think I've been talking too long and I apologize, I'll go quickly. There are, you can imagine a lot of things that are upstream from just passing a new expungement statute. One is giving everybody lawyers to be able to help them with what is a very complicated process. And we have good data on that in Michigan, how many people give up even, when they try. Another is making expungement automatic in as many cases as possible, right? There is no reason why people should have to go to court at all to get expungements if they have earned them, right? If you can come to a decision about who deserves one, automate it whenever you can. Michigan just did that. It's going to make an incredible difference for literally millions of people in the state, just like that. In addition to that, I believe it's time we start thinking about who besides lawyers can help with some of these problems. If, which is not to say that we should give up on additional funding for indigent defense. Indigent defense's infrastructure, is it not? And yet, I think there are certain processes where you could train non-lawyer navigators to help a whole lot more people and we could get it done more quickly. So I think it's time for us to start thinking about our position on regulatory reform. Finally, I think we should be pushing, not finally, I have two more. I think we should be advocating that prosecutors' offices have a role to play in seeking expungements for the people in their communities who deserve them. They have already served at their time and complied with every order the court has given them. It does not increase public safety to continue to stigmatize them with a conviction when they are entitled to expungement. Why isn't that the role of a prosecutor? And why shouldn't the indigent defense community be pushing prosecutors' offices to take that on? And finally, what's really upstream from all of those expungement solutions is diversion and deflection. And we should be sitting at policy tables. Indigent defense lawyers should be sitting at policy tables advocating for diversion and deflection before cases even come to court, after they come to court, and et cetera. So my response to Professor Cho's excellent essay is yes, and.
Well, thank you for that. And there is a lot to unpack there. I mean, as I was listening to you, I really think there are kind of two themes here. One is the example of expungement, right? Which is to say, and there we've got a couple of questions. Who does it? Is it automated? Is it DA's responsibilities? Is it both? And some of that's going to depend on state structure. For example, it's almost impossible in a place like Texas where the records are scattered and diverse to think about automating it easily. So you've got these two options. And then there's the question of expanding the pool of who to include non-lawyers, not just for expungements, but elsewhere. So, and that's kind of one chunk of ideas. The other, which I want to come to a little later in the conversation, is how do we put indigent defense at the table for the larger discussion about criminal legal reform? And so maybe we can divide the conversation into those chunks. On the topic of pushing towards non-lawyers, and you've described them as navigators, the experience, at least in Washington State, for example, when they started licensing limited license legal professionals, is I think what they're called, they didn't have enormous uptake, right? And certainly it wasn't in the criminal sphere. Can you talk a little more about what the vision is that would make this workable in a way that, for example, that experiment has not been so far?
Yeah, I mean, so I say, first of all, look to Arizona and Utah, and now California, in fact. There are other states that are having, I think, far more success with regulatory reform. And yes, I think typically states use civil legal problems as their kind of regulatory reform sandboxes, which is what a lot of them are referring to them as. But I think expungement is a perfect place to experiment with regulatory reform. It's the kind of area where you could imagine having an intake and figuring out if this is the kind of tricky expungement problem that probably needs a lawyer, because it's going to be a full-blown hearing and there are going to be people objecting on the other side. And in Michigan, for example, we have an automatic expungement statute, and then we have a bunch of other convictions for which people can seek discretionary expungement, right? So you could imagine an intake process that separates them. But for the cases where there is automatic expungement, you just have to get the forms filed and pull the records and dot the I's and cross the T's. It seems very likely to me that there are a whole lot of smart people who we could train to do that and do it well and grow our ability to help people access justice. Lawyers are not enough to help people with all of the legal problems that they have. We're not. So how can we grow the pie? And I think this might be one way, and this is one category of reform where I think it would be worth thinking about it.
Thanks for that. Irene, what's your reaction? Because you're focused in on kind of the lawyering piece at appeals and, right, looking backwards.
No, it's true. I think there's something remarkably interesting and engaging about that idea. I will say, just to give you a sense of my priors or where I'm sort of coming from, my disposition is that in everything in the criminal process, I think we should sort of reemphasize the importance of having legal training and having lawyers and having public defenders do the work. Sarah, I was just finishing up Sarah Maya's book, Free Justice, where she, sort of describes the creation and the implementation of the public defender as either very democratic in the sense that you have the state bringing a charge, but because the state protects and cares about individual liberties so much, they fund a lawyer to defend you against the charge. But then it could also be very totalitarian in that the state brings a charge and also is in charge of the lawyer who's there to defend you. I think under the sort of democratic guideline, I think there is something to be said and something critical about the state, actually the government actually funding and providing some sort of professional engagement and licensing for the attorneys that are meant to defend you from the state's overreach of its power. And I'm not yet ready to do away with that in this context. Instead, I'm more of the mindset of getting and forcing and pushing the state to adequately and sufficiently fund it, or to change its decisions about what cases and charges and punishments it levies upon people. I know that could be very high in the sky, idealistic. I know my students, I'm sure, would certainly describe me as that, but I'm just not ready to do away with that sort of push on my part. We'll see as the data comes along how things sort of develop, but by my mind, there's still a role for legal training for lawyers and for the professionals in the system to play.
So, one of the things I'm hearing is this tension between, and this goes back to Bridget, to Justice McCormack's, I'm going to say both, and y'all gonna have to live with it. First comments about, where are defenders at the table? I mean, I think one of the tensions is, are you helping the person in front of you, right? Are you helping the folks who are on the ground in the system and need help now? Or are you taking the harder line that pushes tougher institutional reform that takes longer? And the people who got the skin in the game tend to get hurt along the way. I mean, the classic example of this in a situation far more fraught than an expungement is caseloads, right? Where defenders come in and say, sorry. I mean, Irene, you've been there I think you were there when we had this in Northern, right? Where you come in and you say, sorry, no mas, I'm not doing it anymore. That's it. That's all I can take. It's better to have no lawyer than an ineffective lawyer. So I'm not going to do this. And having represented myself, lots and lots of the people who ended up on those wait lists, the consequences for folks who were in the system could be very high. They were very high. And at the same time, I think ethically and institutionally, in terms of being transparent about the costs of equal justice, about the costs of our insistence on criminalizing pretty much everything and anything, those kinds of statements are necessary. I'm wondering, do y'all have thoughts about how you thread that needle? In other words, are there points? I mean, for example, is expungement the sweet spot where you say, okay, let's bend and go towards non-lawyers, but these other things are the places where you stand firm? Or is it a case-by-case basis? And I don't have any answers, but I'm really curious what y'all think.
Well, I'll jump in first, Justice McCormack doesn't mind. I think both you and Justice McCormack have certainly sort of identified something that's a tension in the work that I do, because so much of what I'm trying to describe is how the public defender could be more of an institution and do its work as a sort of a larger entity than just individual. One of the projects I'm working on looks at public defender discretion. Right. So there's a lot of talk about discretion for prosecutors and the ways in which they make decisions and how they might shift as a path to reform. But I actually think that there's decisions that public defenders make that that we should be sort of thinking through and figuring out if it's the right one. One of the ones that sort of comes from this essay is how much as a state level entities funding going towards appellate and post-conviction work or trial work. And maybe there is a way to see if the society, the improvement, the caseloads or something, get better if there's more money dedicated to appellate or post-conviction work, so that, the attorneys can get involved in some of these reform efforts, right? So, because we all recognize when we talk about misdemeanors and other crimes and collateral consequences, that, removing the impediments that prevent individuals who have been part of the criminal process from fully engaging in society in the way that they would like to, is healthier in the long run. And so maybe some of the public defender discretionary decisions as the institution should shift to account for that.
Bridget?
I think it's a really great question. I wouldn't pretend to have the answer in every application. And I think I probably would end up agreeing with Professor Joe 99% of the time on, when a lawyer is needed, my guess is. And the views I'm expressing today might flow directly from trying to administer a state court system that hears between 3 and 4 million cases a year, where most people are unrepresented in civil cases. Of course, in criminal cases, we get them lawyers, but I think of, being able to access post-conviction reforms like expungement, even though it's technically a civil case, as criminal adjacent. And so it does keep me up a little bit at night that a lot of people who want to be able to access their right to have their conviction expunged simply aren't able to figure out how to do it. They just give up. And we have a really excellent self-help website, but it's just complicated. So I guess I am at this place where so much is up in the air right now. I mean, we've seen more change in the state court system in the last 12 months than in the last 12 decades. I'm not kidding, literally. And that makes me think now is the time to kind of run some experiments. That's not something lawyers like to say, but I think it's time we do a little bit of that. And this feels to me to be one of the areas where, with proper front end screening, like I said before, it might be a place where you want to figure out whether you could train, I use non-lawyer navigators, but there's all different kinds of words for them, other people to be able to take some of these on. And I'm talking again about people who are literally entitled to the relief. They just need help with the steps in getting it, right? A judge doesn't have discretion to deny it. Those are the cases that I'm thinking of in particular. When you ask the public what they think about regulatory reform, and I mean really ask, not just post a question on a court's website saying the court's considering an experiment with regulatory reform, because those draw mostly responses from lawyers who are 2/3 opposed and 1/3 in favor. But if you literally go out and have focus groups and talk to the public about what it means, the number flips. The public is very interested in having more solutions to their legal problems. Of course, again, just funding our public defender system in a more substantial way would do that as well. So that's why I always want to say my response really is yes, and it's not a disagreement with Professor Joe. But Pam, you asked, I think, a couple of questions in your question. One was how to ensure, or how to make sure that people who do indigent defense have a seat at the policymaking table. And I think that's one of the really important questions we should be focusing on, especially right now when everything's up in the air, when we're going to be able to be running some experiments. Why wouldn't we want at the table the set of lawyers who have been standing next to people day after day after day, and have the only unique perspective on what it's like for them in the current criminal legal system? It feels like their voice at the policy table, it's malpractice not to have it there. But it's not necessarily something that we are trained to do. It's not necessarily something that we're even comfortable doing, or we think it's our place. And I'd like to encourage us to change that and to think about changing that. And I think law schools have a part to play there. I think clinics have a part to play there. I think centers like yours have a part to play there. That might be one of the things that we could think about institutionally going forward. How do we make sure that people who are standing next to people who are most impacted by the criminal legal system are then at the table when we're thinking about reform? Because then they might say, what are we going to do to make sure these people can get this relief that we are so proud of, passing?
So I think this is a great point. Short war story, which is after Katrina, for many months, the Louisiana Supreme Court would hold what I affectionately used to call kumbayayas. And it was the US Attorney's Office, and it was the DA's office, and all of the policing agencies, and probation and parole and corrections. And for a very long time, those meetings were held to plan what to do with the post-Katrina New Orleans criminal legal system. And there was not a defender in the room. And when it was pointed out to the Chief Justice, she immediately said, "Oh, of course, we want you there." But it took a very, very long time to be invited to the table in a system where it was national news that you had literally thousands of people in jail being represented by a bunch of law clinic students. That was it. And so I don't think it's natural or assumed by people who hold power, or has not historically been assumed, that defenders have a contribution. I think defenders tend to be viewed as, in part, as I think Irene might agree, as a function of our ethics, right? Viewed as, you take one client at a time, you pretend you have no other clients while you're standing there with that one client, which is a whole different fiction. And therefore you don't have anything to say systemically. And so I guess I want to ask you, having made the transition from, being from the bar to the bench, what are defenders not understanding that helps, that's making the bench, that's making the bar overlook them as part of the solution? Do you have new insight on that from where you sit now?
Well, I don't think I'm not gonna say it's their fault. I think some of it is, role train. I mean, I went to law school so long ago, although I do continue to teach at a law school. So I hope I continue to have some sense of what happens there, but not like you all. But I think there's something about going to law school and learning the skills and values of having, complete allegiance to the person you're standing next to, right? And solving their problems, right? And that's in fact, it might be, it might put you in a conflicted position if you try and work on problems that overlap with your individual clients. I think there's something about our training that makes it a little bit not totally comfortable to say, we should really be at that policy table. But I think that the more I have worked on criminal justice reform issues, and I just finished co-chairing the governor's task force on jail and pretrial incarceration, and I'm now co-chairing the forensic science reform task force and a couple of others. The only way we're ever successful is if we with complex problems, which criminal legal system problems are, is if we surround the problem. And I mean by that, every stakeholder who plays a role in the in creating it, which we all do, right? I mean, just let me say what I mean by that. That county jail populations have tripled over the last 50 years, even though crime is at a 30-year low. And it could well be that everybody acting in good faith plays one little part in that, but nobody can walk it back unless we all surround it together and figure out like, hey, is this where we want to be? Is this making our communities any safer? And so I don't really think you get reform done without in the indigent defense bar at the table, criminal justice reform, without the indigent defense bar at the table. I really don't.
Irene, thoughts about this? I mean, you were there.
No, I think, of course, I think Justice McCormack is absolutely right. One of the things that she says that sort of triggers a thought for me is one of the questions I have in my research is, what are the hard and soft skills we would want to see in both the line defenders, but also in the leadership? Like, so whoever is the head of the office, is this somebody that, their focus is really on sort of the policy discussions and the policy battles? Or is it something else with the leadership of the office? The late Deborah Rhodey from at Stanford Law School, she wrote a lot about leadership, and some of our conversations was, discussions about, what it was like for me starting off as a brand new attorney under the leadership of Brian Stevenson at EJI, and sort of what he had created there, and then being able to join the OPD and seeing, Derwin Bunton sort of start as a leader in that office and try to build something there as part of the group. But, I think we have a general sense of what we want in our defender leaders, but I'd be curious to see what research would bear out in terms of what's ideal for a particular type of office, a particular moment in time, such as we are right now.
So
I think that's really interesting. Oh, sorry, Pam, I didn't mean to hop on you.
Go right ahead.
I think that's a really, really interesting point. It's something actually I've thought about just in court leadership. We're not, every court in Michigan has a chief judge, and then we have a chief justice, and lawyers are not necessarily good administrators, good managers, or good leaders, right? I mean, it's just not something that comes naturally, and it's not taught in law school. And when I list a set of things that makes it very hard to see wholesale reform in both the criminal justice system and the civil justice system, leadership is on my list. It really is. So I think that's a really, really interesting point. I'm glad you raised it.
And I was just going to comment, first of all, just wanted to let our audience know that starting at around 4 o'clock Eastern time, that would be 3 Central, 2, and then 1, wherever y'all are, we'll be taking starting to answer questions, but our audience today actually includes some chief defenders from offices, right? Former and current leaders in offices, and hopefully they'll feel free to weigh in the chat box with some of their questions. I do want to reflect back this idea that leadership matters. Paul Heaton and I are winding down a study right now looking at 4 defender offices in a single court system in Seattle. Cases are randomly assigned within the size of the office and caseload limits to different judges, different parts, different assistants. And when we looked at 4 years of data, even though the funding levels were the same, the court rules are the same, everything's the same, the offices had very different outcomes. And as we began to dig in, and we're not going to have all the answers, but as we began to dig in, it became pretty clear that there's a culture piece, right? In terms of what the office culture is. And I have at least a strong suspicion, although I'm not sure I can prove it, that a good piece of that comes from the culture and origin stories. I'm going to go into my comic book geekiness, the origin stories of these defender organizations and how their leaders understood the defender role. In other words, did the leaders see themselves as people whose obligation was not just one client at a time, but someone whose obligation was, for example, to engage in the larger community, to think about systemic reform. And Seattle's such an interesting place to do that because, of course, that's where a defender, Lisa Dogard, launched the LEAD program, which has now become kind of a shining example of front-end reform, right? It's front-loading the reform away from defenders who are on the receiving end, but with information that only defenders can provide. I don't know that I have any answers, but I'm really intrigued by that observation of Irene's. And I guess I'll say also rather painfully, I think we see that not simply at the office level, but in those states that have indigent defense commissions, right, that are statewide and regulatory. You see sometimes, in Louisiana is a great example, and sometimes very horrifying and painful ways, the difficulty that a change in leadership can make in the strength of an organization. Which brings me to this question that there's not an answer to, but I want to ask it anyway, which is the only part of the criminal legal system that is actually required in state courts, other than if a state's adopted the grand jury, okay. But the only other part that the United States Constitution incorporates to the states is in fact the right to counsel. And yet in the pandemic, right, it's the first thing to go, right? The speedy trial goes, your access to counsel goes, it's delayed, it's denied. What is it? And is it a leadership problem that leaders aren't stepping into this breach that keeps defense from being centered in this system where it should be, I think, under the Constitution, and instead pushes it to the margins?
I don't know. That's a great question. I'm glad you prefaced it with, it doesn't really have a great answer, because I think that's right. And I don't know, at least I like to think that the kinds of things that have happened in these last 12 months are extremely unusual. And so you've heard me say here today, in addition to a lot of the things that you just described, there's been incredible innovation in courts. I mean, some of which has benefited, criminal defendants. In Michigan, the executive director of the Association of Sheriffs and I together issued a joint statement at the start of the pandemic, encouraging chief judges in every county and their elected sheriff to get their jail list together and figure out whether people really had to be there. And Michigan's county jails populations reduced between 25 and 75% statewide. At the same time, we have judges now who send police officers out with iPads to local homeless shelters and parks to help people clear warrants so they don't have to come to court. And that just never would have happened without a pandemic. So I'm still trying to see the innovation benefits that we might get out of this that might help us with front end reform going forward, as in the Seattle example. But you're right that reform needs the voice of the indigent defense community. It just needs it. I mean, there's just nobody else who has that perspective, who can put that, who can put a certain perspective on the table that people need to understand to make decisions.
Irene?
Yeah, I am very much with Justice McCormack here, and I also don't have a good answer to your question. One of the things that comes to mind is possibly one of the reasons that public defenders are, sort of so quick to be pushed aside, or even though they're so critical, as evidenced by their inclusion in the Bill of Rights, the right to counsel, is for so long and for so much of time, public defenders just make it work, right? So they can have the minimal resources, maximum workload, and somehow, because of their commitment to the work, because of their abilities, I'm not sure, because of the superpower, I guess, to sort of, pick your comic book vibe up, they make do. And so it's easy for certain institutional players to say they'll figure out a way to make it happen. And so maybe part of our responsibility, or I guess I'm not a public defender anymore, I sometimes still include myself in that, but maybe part of the public defender responsibility is to stand up, be loud, and make it clear that they can't make certain things work. And so they're going to need the resources, the support, the time and the attention and the dedication to doing their job. And they're not going to give you just satisfactory because they can. They shouldn't have to.
But that requires a certain amount of political capital, which brings us back around to something we were talking about earlier and that you alluded to, right? The nature of the practice is that you represent an awful lot of disenfranchised people, and depending on where you live, an awful lot of people whose ability to vote is consistently being constrained, right? Because of who they are, where they live, the color of their skin. And you add to that the enormous power that sheriff's associations, police associations, DA associations have in terms of legislative power, right? Lobbying and working with legislative powers. And I wonder whether that isn't in some ways just an unsolvable problem, at least until you fix felon disenfranchisement. And I don't mean to be like totally a downer about this, or maybe I do, but I think often that even, for example, as Justice McCormack says, the best intentioned prosecutor or sheriff probably is not going to have the insight that a justice involved person or their lawyer is going to have. And yet there isn't, I'm not aware of a single state where, for example, there's a defense lobby that has anywhere near the political weight or power of a sheriff's association or district attorney's association. I mean, I don't know, is there a sci-fi world where that happens?
No, I don't think I'm aware of any either. And, but I know you're all aware of how many groups have emerged from the public who care about reform, right? And they're incredibly active. I mean, the Michigan Jail and Pretrial Task Force took public comment across the state, and we had hundreds and hundreds of people in both Detroit and Grand Rapids and Traverse City. I mean, it didn't matter where we were. We had people who had been impacted by the criminal legal system, many, as you well know, on both sides of it, right? They had been survivors of crime, and they had been arrested and spent time in county jails, and they had a lot to say, and they're the voices of clients that lawyers have a role to play in organizing, helping to make sure they understand how they can have their voice heard, can be pretty important. So I don't think it has to be sci-fi. Am I like the Pollyanna-ish person on this panel today? How'd that happen?
You might be, which is really weird, but you might be.
Yeah.
Maybe it's because you now have power, right? When I'm just theorizing here. But so it does occur to me though, and there's a question that just came in on one of the comments that reminds me, another piece of the puzzle is in many places, defenders don't have the kind of independence we're describing. So you can look at systems where judges really control the appointment of counsel, systems where there is no public defender system that's organized formally, or where there is, it has limited power. Places even that do have defender systems where the appointment of counsel system, which is supposed to roll out on a wheel or on a list, is routinely evaded and avoided. And what you end up with, I think, is often these terribly conflicted situations where, even more than in the normal work group scenario, lawyers feel themselves beholden to the judges, not just for the scraps of favors or things that they might get on a particular case here or there, but for their ability to eat and put a roof over their heads. And I wonder if you guys have thoughts about, both in the context of line defender work and Irene, also in appellate work, what is the relative importance of independence, and what does true independence look like for defenders? Irene is laughing, so I'm calling.
I think these are all questions that I'm still trying to answer. I have a project that looks at how different states sort of manage the public defender, and how the provision of services, either sort of existing under the state sort of executive branch and executive authority, or the judicial branches, or independent, sort of done at the county level, and trying to get a sense of which is better, or which works better for different purposes, right? I think that, especially with the federal defenders, and a lot of their push to not exist under the judicial branch, to sort of be independent, that's something that's really fascinating and might work for them. But one of my concerns is that how does an independent defender sort of jostle for state resources at the same sort of level that the functions of the executive branch or judicial branch do. So I'm not sure if we're really looking for that kind of independence at an early stage of the public defender's existence or just sort of gaining a foothold in the criminal process. I don't know. These are still questions that I'm trying to figure out through my research. I know when I was a defender, all I thought about was independence and, it just seemed right. But now that I'm on this side of things, thinking about how sort of the management and the structure and and sort of creating a system that's self-perpetuating, I'm curious about whether we do want that strong, clear, severe sort of independence. I'm not sure. Hopefully I'll have an answer on that sometime soon.
Do you mean that the alternative to independence is some kind of protector or champion? Is that what you're suggesting?
Exactly.
That you want a Justice McCormack or a, defense sensitive governor more than you want to just be out there on your own?
I think that's exactly right. The defender needs some sort of defender. All right. And actually, so this semester I was teaching criminal procedure. We just finished classes yesterday. And I actually had a few progressive prosecutor classes, right? And we had a progressive prosecutor come in and talk. And one of the questions that the students asked and I asked, and I was very focused on was, okay, we're still trying to figure out how to define a progressive prosecutor, but what does that definition look like in terms of how you interact and treat the public defender that you're in opposition to? And I think that's a very important part of the definition. How are you sort of supporting the public defender's ability to do their job and to do it well? And maybe that's through the charging decisions that you make. Maybe that's through the plea offers you make. Maybe that's through the ways in which you are campaigning or suggesting or pushing forward support and respect for the institution that hasn't been done in the past. But I do think that the progressive prosecutor mantle has to include some new relationship or consideration of how the prosecutor interacts with the public defender.
Of course, though you're saying the public defender, and of course there isn't just one. I mean, I'm mindful of Kim Taylor Thompson's work on this subject, right? The idea that the institutional defender has one role, but conflicts being conflicts, right? No one defender can speak for all defendants. I mean, so Bob Barukowitz, who is in the chat right now and watching, and of course, Bob's a former chief defender, a law professor, and has decades of experience thinking about these things, is asking, well, why not a defender general like an attorney general? Bridget, you have a reaction?
My first reaction is, hi, Bob. It's been, 30 years? All right, maybe not quite that long time, but I'm so glad you're here. I actually think this is a really intriguing idea. I mean, why not have that kind of elevation of the role, right? And therefore have somebody who's in charge of these kind of high-level policy-ish decisions and will always be at the policy table, right? If we had a defender general, the defender general is going to get a seat at the table every time the attorney general gets one, right? So it's one way to institutionalize putting that perspective at the policy table. So I've thought about it now for about 45 seconds and I'm in favor.
Well, I mean, that's probably just a little bit less than I've thought about it. But in all seriousness, I mean, there was a paper about this not too long ago, and I think maybe Dan Farber, I can't remember. But the other advantage I see to a defender general is this: the best appellate issues and the most egregious examples of police misconduct are often the ones that are hardest to hit the appellate courts, going back to Irene's concern about appeals, precisely because they get traded away in an individual system that focuses on individual ethics, right? So I know there's a bad cop. I can walk my client or I can out them with a suppression hearing. I'm walking my client, right? And the defender general does offer the additional benefit of someone who doesn't have that individual allegiance and therefore who can think systemically. I mean, one way even to understand what makes a high quality defense delivery system, and this is something we think about a lot at the center, would be to say, how do clients do in terms of legal outcomes? How do clients feel about their process? And how well does the defense system protect the Constitution, meaning enforce the Fourth and Fifth and Sixth Amendments? That's a place where there's an inherent conflict. And maybe that's what the defender general does best. I don't know, Irene, you have.
No, I think those are really great points. I see in the chat, there's some comments about, so Daniel Epps had a paper called The Defender General. That might be the one you're sort of speaking to, or, you know, he sort of fashions it, if I recall correctly. It was a public official that would be sort of representing the collective interests of criminal defendants. I had a piece, so I have a piece called Structure in a Public Defender that, and then wrote a small little piece for the Atlantic that talked about creating sort of an inspector general type figure for the public defense function. And so this would be a defender for the attorneys that provide services. And that would be sort of their advocate at the table. And so I think these ideas, there's something to this, and they're part of a really interesting discussion.
So we've got a question going back to this question about independence, which I think doubles back again on this question of, do you have an inspector general, who holds the power? And the question is the financial and kind of governance independence different than the independence at case by case individual advocacy levels, or are they just two sides of the same coin? This one's to you, Irene.
I would separate them, I think, but that also goes to the question I posed earlier about what do we want our defender leaders to look like? Do we want their focus to be about sort of the individual representation and making sure that each each client is provided, you know, however we define their Sixth Amendment right to counsel and competent and effective representation? Or do we want their position, their client, to actually be sort of the provision of services itself and the ability for the line attorneys to do so, for the system to provide services? You know, the way that I think about it in my work, and that I'm certainly trying to push forward, is that latter one, you know, sort of, so you have this leader that's thinking about the institution and the health and security and stability of the institution, as opposed to sort of thinking about individual clients.
So Bridget, you've been on both sides of the bench now, and I'm thinking of, actually, now that we have Bob Barukowitz watching here, of a case where Bob and Ellen Yarashevsky and some other folks we all know actually testified in an indigent defense case about resourcing, that it was a judicial responsibility, that there was an ethical violation for a judge to preside in a scenario where they knew that the defender was underfunded and under-resourced. Where does the responsibility lie, and what's your thought about the independence question? Two sides of the same coin or different? Two questions.
I kind of think they're two sides of the same coin, but I think Irene knows more about this than I do and is thinking about it more full time. So I don't trust my answer, but I think of it as just one is the specific application of the other more than, you know what I mean? Rather than two sides exactly. I think it's one side, just one side in its specific application. But the judicial responsibility for adequate representation strikes me as exactly right. I don't know. I mean, you know, it seems to me the judge is the person in the courtroom who has the ability to do something about that problem when she sees it. And if she sees it and doesn't, I'm not sure. I mean, I can think of a number of specific ethical problems with that, in addition to some moral ones. So I don't know if I know that case. I probably did at one point, but I'm old and my brain doesn't hold everything anymore.
I don't think it ended up in, Bob will correct me in the chat if I'm wrong, but I don't think we ended up in that case with a Louisiana Supreme Court opinion. It hit the district court. I think it went to the Fourth Circuit in Louisiana. I don't think we got a major decision. Yeah, Bob says no appellate opinion, so I'm not crazy. Okay. But the theory was a really interesting one, and it gets at this problem that I think everyone who's been litigating the right to counsel cases is experiencing, which is that there's not a great return on investment. If you look at the case litigations, you look at the work coming out of Steve Hanlon's Delphi studies, you look at all these different ways that people are going after the problem, there hasn't been a ton of traction, part because of abstention doctrine, partly because of some larger questions about separation of power in some of these state government structures where there's a commission and they get their money from the legislature, but they're commissioned from the governor. What is the role of litigation, not so much against the judge, but the role of litigation in helping strengthen independence, helping obtain funding, and is that litigation another way to put defenders at the policy-making table?
I mean, yeah, absolutely. I mean, litigation is like lots of other tools. It's a tool, right? It's a tool that can be a really effective tool. And even when it's not ultimately effective, the litigation itself, it can put the right people at the right table to solve problems in more upstream ways. So even though I think litigation is as downstream as anything in, if by the time we get to litigation, everything has gone wrong. We have not solved this problem at, the 20 points earlier in it that we should have. But sometimes that's where you are. And if that's where you are, then you have to use that tool, right? If that's the tool that's called for, then that's the tool you have to use. And hopefully it is one example of a way in which we get the right people at the table solving these questions so that we don't have to litigate again the next time. So yeah, litigation has brought about some important reforms, right, throughout history.
Well, and Bob's referenced the Wilbur case, which is a Washington State case where Eileen Farley, a former chief defender, ended up becoming essentially a special master overseeing the quality of defense services. There's also the Hurl Herring litigation in New York, small brag, right? Andy Davies, who's our research director, was the chief data scientist at the New York State Office of Indigent Legal Services when that litigation put together. And that litigation is pouring literally millions of dollars into defender offices to lower caseloads. One really interesting thing, though, is that both of those litigations harken back to something you said very, very early on, Bridget, which was look at the data. I mean, you were talking about access to counsel and what it does, counsel at first appearance, you were talking about, but data seems to be increasingly, well, it's a sword and a shield, right? But increasingly an important tool, both in finding ways to talk about what a good defense does, however one wants to define that, but also what a failure to provide defense costs.
Oh yeah. I absolutely agree. And as you all know well, criminal justice data is terrible everywhere, right? It's just terrible. I mean, as you said, in Texas, you could never have an automatic expungement because apparently the records are not findable because there's no IT system that could possibly create an upstream automatic expungement solution because apparently all of your IT systems are so terrible, it's just impossible. And we're all kind of used to that, right? We just throw up our arms and we're like, oh, we just have terrible data. So, I guess we'll never be able to actually know what the data could tell us about some of these potential upstream solutions. And that, I'm here to say, is definitely infrastructure. I am definitely see building better court and beyond court criminal justice data systems as really important to solving problems in upstream ways for indigent defenders, but more importantly for impacted communities. It's critical that we fix our criminal justice data problems. I don't know if we'll get there, but we're working on it in Michigan.
Irene, okay, now you're studying it, but before you had to live it, how much do defenders who already have too many cases love doing data?
Yeah. Oh yeah. No, it's that we ask a lot of the defenders, right? And so, my hope is that, it's not us adding something to their workload that they won't be able to see sort of more immediate returns from. And that might just be the way in which we gather the data and how we use it at different turns to get them some sort of relief. Maybe that's what we can be creative about in that work. But no, that's that's a lot to ask.
Well, as fascinating as this is, I promised I would let the audience ask some questions, and there are some really, really good ones. So the first one is I think a question that's probably painful to all three of us, but a real question we have to grapple with, and it's this. Do quote unquote progressive prosecutors and extraordinary criminal defense attorneys actually do more harm than good in perpetrating injustice in the criminal legal system, essentially by validating a system that we know to be corrupt? In other words, is every time someone says, ooh, the system is working, are we just kind of helping sustain a corrupt system that doesn't in fact work? That's a depressing question, but it's a real one.
I'm happy to jump in. That was we're a week and a day outside the verdict in the Derek Chauvin trial, and that was a lot of the conversations that I had both with the media and then with students and with other system, and also some of my old clients who called and spoke with me afterwards. There was so much of this broad idea. Several times I had to really sort of get reporters to calm down with, oh, this proves that things are working, right? And just sort of having to emphasize for them everything that was involved in getting this one outcome and how unlikely it is to exist in the many other similar cases should be proof that the system isn't working. The fact that it takes superhuman strength or a global pandemic and a moment of historical racial unrest to get an outcome in a case that so many would have considered sort of basic. That's more of an indictment of what we've got than a glowing sort of review of it. And I think that maybe that's part of what system actors could be saying and showing more. It's not just that we were able to do something here. Here's all the things that still exist that are a problem, and here's what was required for us to be able to do this sort of superhuman feat.
I'm reminded very much of, I think, a sort of a discomfort that many of us sometimes have around innocence projects for the same reason. Not that their work isn't critically important, but that they might create the false impression that somehow there are very few errors and they work themselves out. I mean, I'm thinking of Abby Smith's piece, about needing a guilt project, right, rather than an innocence project. Bridget, anything you want to add on this topic? Because I'm sure it's one you've thought about.
Yeah, I mean, and here I go with my optimism again. You guys didn't set me up to be this today, but here I go. I don't know. Maybe it's because I'm, part of the system. But I think excellent defender offices that are doing innovative work and making a real difference for their clients' communities, their clients' families, and progressive prosecutors who are truly doing the same thing. I mean, there's a spectrum of progressive prosecutors, of course, right? Not every progressive prosecutor is created equal. But in Washtenaw County, Michigan, where I live and where Ann Arbor is, we recently elected a progressive prosecutor, and he has a full-time, very talented attorney doing expungements. He's doing exactly what I said. He thinks that the people in Washtenaw County who have, by the statute, done everything they're supposed to do, and they therefore deserve to have their conviction expunged, but they're unable to figure out how to do it, or might not even know that they're entitled to it, right? That's also a problem. People don't even know. He thinks it's his job to go get it done for them because it's not making his community safer. I don't know how to say that's not going to have an impact. It's going to have a tremendous impact. I know people it's going to have an impact for. And for many of them, there's nobody else who can do that right now because we haven't gotten to regulatory reform yet, but we will.
No, this is back to that perpetual tension, I think, which is excellence for individual clients versus addressing systemic reform. And it's very hard to manage both, and even excellent offices that do that, I think, are few and far between. And they are so wildly resourced compared, by which I mean wildly well-resourced compared to most defender offices. I'm thinking here, for example, of PDS or of a federal defender office, right? That it's hard to imagine they're representative. But I do think that you have kind of the salutary examples, right? And then you have kind of the broader range of practice. We have another question here from Professor Eve Hannon, who first of all says, forgive me, Professor Joe answers this in her article, which I have not read. You couldn't because it's not published yet. And she says hello to Justice McCormack, who is her former clinic professor. So your little chickens are coming home to roost. But her question is, could an adequately funded post-conviction counsel do something about all of these issues by really creating a foundation that documents why it is that you need oversight, funding, and training for trial counsel? So, is there a case that you'll get some kind of a feedback loop? I wasn't asked, but I'll say I'm sort of skeptical about it only because of how few teeth we actually have in Strickland, that I don't think we get a lot of that information in the judicial opinions. But I think you could, if we were paying more attention and actually bothered to look at the performance prong of that inquiry. But what are y'all's thoughts?
I love that idea, and that says a lot about the quality of your clinical professor, Professor McCormack from back in the day. Because, and I should stop sort of patting myself on the back about this. I'm actually working on a project right now that looks at the feedback loop between trial attorneys and appellate attorneys. It's called Learning from Mistakes, and it's just it questions how individual trial public defenders actually learn from, the problems that are brought to the forefront when their cases go through the appellate process, and then post-conviction counsel or appellate counsel puts together a brief saying these were the things that may have been subject to IAC, even if the court doesn't come back and say and agree, right? That's still an appellate attorney who has sort of put down a marker and said, this is something to consider. And so maybe in the future, this is something the attorney thinks about changing. So I just have to say, excellent idea. I'm glad that you pointed that out, because that's certainly something I'm thinking a lot about right now. The project itself really looks closely at death penalty cases. And looks at the ones that have been overturned, right? So the wrongful convictions in the death penalty context, and says, in this situation where you've got, this extreme sort of punishment, the cases that get, reversed based on, I have ineffectiveness of counsel, but then also prosecutorial misconduct or actual innocence. What lessons do public defenders take from those? With, of course, the prosecutorial misconduct, it's behavior that the prosecutor has made, but maybe that's a shift how you as an individual, your office interacts with that prosecutor's office going forward, knowing that that's been some sort of behavior in the past, and then the same sort of reasoning for actual innocence. So I think in general, we're missing, or we're not doing enough with the feedback loops in the public defender context, and the appellate trial attorney relationship, I think, is a really important area to look at.
So sort of a sentinel events view of how defenders operate, right? Or a systems approach to defense operation.
Exactly.
Is, something you and I should at some point hook back up and talk about. Bridget, anything you want to add on that before we?
Yeah, I just want to say again, it's not just the lack of feedback loop learning that you might see within the indigent defense community. It's the criminal legal system. I mean, we're terrible at risk management, right? I mean, when you think about what happens when a plane crashes, or a patient in a hospital codes who shouldn't have, the error management processes that are in place in these industries that are life and death, like this one, are really make it a little bit hard to understand why we don't do risk management better, why we wouldn't want to learn from what we now know a lot about what goes wrong. And it's not just lawyer mistakes, although obviously lawyer mistakes is one area where we have a lot of information. But from the DNA exoneration database, we also now have a lot of information about prosecutorial misconduct, about forensic science error management, about false confessions, about bad identifications. We actually know a lot about what goes wrong in the criminal legal system to cause wrongful convictions. Of course, lots of things go wrong, even in cases where somebody might not have been wrongfully convicted. But still, we only look forward, right? So there might be an opinion published that highlights any one or sometimes more than one, as you know. You'll often see both ineffective assistance of counsel and some other error that the government is more responsible for, not the lawyer. Those go hand in hand all the time. And maybe in that individual case, the error gets corrected, maybe. As you know, maybe it's a big maybe, because it might depend on like whether the appellate lawyer knew to raise the right issues at the right time and blah, blah, blah. And it's so hard to even fix it in the right case. And then we never think about it again. We don't do any risk management going forward in the entire legal system. And I don't get it. Why is aviation so much better than we are? We're both life and death, right?
So my quick answer is because you can't recover in legal malpractice in a criminal case the way you can after an airplane crash is part of it.
Yeah.
My cynical answer again, because you're the optimist. And I'll also say Andy Ferguson and I did a project about this a couple of years ago. We wrote a piece called Defending Data. And part of what we argued is, we need to find the errors and the near misses, not just in the capital cases, not just in the LWOP cases, but in day-to-day practice. We need to be promoting a culture in which defenders are talking to each other about, I screwed up, how do I avoid it? So this has been fascinating. Unfortunately, we're at a point where I got to cut us off just about. So I wanted to ask you if you could each quickly, and I mean 60 seconds, offer some advice to the students and young defenders and young lawyers who are watching, who really want to make a difference in criminal legal reform generally and in defense reform specifically.
I'll go first so we can let the Honorable Bridget McCormack have the last word. I think that'll be really meaningful for the students. Just by my mind, it was such a joy to work on this project with two of my students who are heading off to do criminal justice reform, Shelley Richter and Deja Tillman. And the conversations I've had with them have been to really sort of spend time thinking about why you want to do this work, and then pursue the opportunities to learn from people who will help you think about how to do it in a way that's meaningful for you. So Shelley's graduating in a couple of weeks, and I'm really excited that she's going to be clerking for Justice Pickering of the Nevada Supreme Court, because I think that'll help her sort of capture and put to mind sort of how she's going to approach this work and do it in a really sustainable way. And then Deja's a 2L. She'll be with the ACLU Capital Punishment Project this summer. And as we talk about, what she might do post-graduation, hopefully clerking and then other stuff, sort of thinking through what's the right sort of entry for her and the right environment for her and the ways in which to do the work that really reinforce and support her designs and ideas about how justice should be handled. I think it's important to spend some time really deciding that for yourself, and then looking for the leaders or the guides and people out there to help you make that the reality.
Bridget?
Yeah, again, I also want to thank everybody for including me in this conversation, and thank you to the students who are tuning in because you care about this really important set of questions, and I'm really excited for the difference you're going to make. I think the thing I want to leave you with is, I don't know how to say this enough, but we are at a really important inflection moment in our justice system. There really has been more change in what happens in state courts in 12 months than in 12 decades. I'm not kidding you. If you looked at courtrooms last February, they looked a lot like they did after the 1918 flu. They really did. We did things the same way. And all of a sudden, everybody had to learn to do things differently. And what that means is a lot that has always been assumed as like, that's just the way we've always done it, is now kind of up for grabs. And you are entering the legal profession at a really exciting time, because I think you can have a tremendous impact on what it looks like for your neighbors and your kids and the people you love and the people you don't even know. And I'm really excited that you care and that you're about to do it, because now is, I think, the moment where we can see really important change that we've been talking about our whole career, Pam, you and I, and I think, and working on, but maybe achieving around the edges and not putting a spear through the heart of the system. And right now, I think that the system's ready for the spear. So thank you all for grabbing your spear. Let us have it.
Well, thank you both again so much for joining us. And thank you to everyone who's with us in the audience.